and I went through the second cohort of SheBoot, and it was just such a fantastic program that I've since come back as a workshop leader, a coach, and an investor in the program. I think it's fabulous, and I think that you're all going to learn a tremendous amount. In particular, how to talk to investors and how to raise money. I'm a co-founder of a company called Fortress IAM, and that stands for Intangible Asset Management. What we do is we help SMEs manage all of their intangibles, which includes your intellectual property, your patents, your trademarks, your trade secrets, as well as contracts, which we'll touch on today as well. And so I'm delighted to be here, and I'm just going to launch in. We do want to keep it fairly interactive, so if anyone has questions, feel free to put your hand up, either in reality or using the little button. And if Katie, if you see that anybody's asking questions in the chats or anything, just let us know. And yeah, and hopefully we can keep it interesting, and you'll learn a lot from it. I mean, our main goal today is to enable you to articulate your IP strategy, which may or may not involve patents. It doesn't always involve patents, and to be able to share that with investors. So intellectual property belongs to a broader class of assets called intangible assets. And I didn't want to just focus on IP today, although IP is incredibly important for any innovative company. But I just want to make you aware that there are other intangible assets that also can drive value for your business. So if we look at this slide here, you'll recognize some of them as intellectual property type of assets. So under invention, of course, here we'd have patents. Under designs, we'd have industrial designs and design patents, as they're called in the US. Under confidential information here, we would have trade secrets. They're one form of confidential information. Under brand here, this is where we'd find our trademarks. But also you can have other intangible assets there as well, such as goodwill. And reputation. But in addition to that, other things that you can think about that might be driving value for your business are things like relationships. So if you have really proprietary, valuable relationships, for example, with vendors, suppliers, your customer relationships, these are all also things that can drive value for your business. And some of these may be managed through contracts. Also approvals and certifications. If you're in a heavily regulated industry and it can take quite a long time, to get these approvals, that's something else that adds value to your business. Software, of course, that can be protected through intellectual property, and also the networks that you develop. Whether it's your user base, your community networks, and then data. Data is something that we're going to talk about today, because I think data is becoming more and more important as an asset that drives value for businesses today. And plant varieties we won't cover today, but they are becoming important again, especially in fields like cannabis, where companies are actually engineering new strains of plants. Why do intangibles matter? Well, we basically moved from a tangible economy where companies were valued based on things like buildings, equipment, inventory, to an intangible economy where, if you look at the top 500 companies on the S&P index, over 90% of the value of those companies is actually held in intangible assets. And of those, IP and data are the most valuable. So essentially, IP and data have now become the most valuable business assets and also national security assets. And basically, as the global marketplace continues to expand, companies are no longer protecting their turf, based on local, markets. I'm now really you're defend your turf based on intellectual property rights in the jurisdictions where you operate your business, and also in terms of proprietary data and how you manipulate and control that data. Now, there are lots of different types of data that companies have. And of course, at the base, we've got your business data, your customer data, sales data, and financial data. If you're in a research area, you'll have R&D data. That could include things like clinical data and other types of experimental data. You've also got engineering data, especially if you're in the software space. And in particular, the types of data that are proving to be incredibly valuable in today's marketplace are things like user data, being able to really collect data that actually like helps you understand your customers and markets. That data can be packaged, it can be sold, it can be kept as a secret. And then things like structured data. So if you're actually able to take raw data and put it together in such a way that you can gain valuable insights from that data, that type of data also has a lot of value for innovative companies. And then, of course, there are things like data sets, which are becoming more and more important, in particular in fields like AI, where you might be putting together training models for artificial intelligence. And so going from the large natural language processing models, what we're now starting to see is more and more niche data sets that are targeted to particular industries or to particular problems. And there can be a lot of value in that data as well. And moving on to intellectual property. So what is intellectual property? It's quite a broad term that essentially covers any creations of the mind, right? Any man-made or woman-made creations of the mind. And so this can include things like inventions, which we'll talk about more, literary and artistic works, symbols, names, images, and designs. And the important thing is that it's used in commerce. That's really one of the ways that we think about it in terms of why you would want to protect this. And under intellectual property laws, owners are granted rights. So these are legal rights, and they are exclusive to the owner of those rights. One thing that's really important to remember about intellectual property rights is that they are exclusionary rights. They give you the right to stop others from doing something. They do not give you the right to do it yourself. And that's where your freedom to operate comes in. And we'll talk about that later. Just because you have a patent, for example, doesn't give you the right to go out and make and sell your patented product, because you might be infringing on others' rights in doing that. But whatever is protected under that patent, you can stop others from doing.
What an interesting little point there too is that when it talks about creations of the mind, so it has to be something coming out of the mind. One confusion I learned with employees when they were signing IP contracts was, you can't patent what's in your mind, right? You walk as an employee, you walk away with the knowledge in your head. You always have that knowledge. Nobody can take that away, luckily. And otherwise that would be painful. But so, as employees leave your business, they walk away with what's in their head. But if they've created something for you and you have a good IP contract with them, then you maintain that creation.
Yeah, absolutely. It's the expression that can actually be protected under intellectual property. There are lots of different types of intellectual property to consider. So as you're looking at your own company, you should be thinking about any and all types of intellectual property that you might be able to employ in your IP strategy. The most common, of course, being patents, trademarks, confidential information, and copyright. And we're going to talk about industrial designs, and we'll talk about some of these today. I already briefly mentioned plant varieties. Geographical indications are interesting. So that's something that's kind of more in the trademark field. And that's where a particular product becomes so recognized, as being from a particular region or geography, that it actually becomes part of their brand protections. For example, things like champagne. It has to be made in the region of Champagne in France. And then there's also integrated circuit designs, which can protect the 3D structure of circuits. There's a lot of information on this slide, but I did want you to have a takeaway just to be able to understand the different types of IP and just some of the important things to know about them. So trade secrets, we're going to talk about that today in more detail, but basically this is business information that derives its value from its secrecy. Basically, it can be any eligible information that has some sort of economic value to your company. So that's the difference between confidential information and a trade secret. Anything can be kept confidential, like your HR information and things like that, but that's not really considered a trade secret unless you can actually derive economic value from it for your company. Those are the types of confidential information that's eligible. The nice thing is that it can last indefinitely as long as secrecy is maintained, but you do have to really diligently protect that secret, and you have to be able to prove, in the case of misappropriation, that you did take reasonable measures. And we'll talk more about that. Industrial design. So these really are more for the visual shapes, patterns of a type of an article. It's not related to function at all. And these are a type of registered right. So you do apply for either an industrial design or a design patent in an office. In Canada, industrial designs have a life of 25 years. You do want to actually file for an industrial design before you disclose that design to the public. Patents, I'm not really going to go through because we're going to talk about those in detail, and same with trademarks. But I do want to mention copyright because we're not really going to go into that today. But basically, copyright protects literary, artistic, and dramatic and musical works. So basically, that type of a creation. It also includes software code. But one thing to keep in mind about copyright is that it really only protects against substantial copying of the copyrighted material, which means that if it's changed in some way, it may no longer be protected by copyright protection. So it kind of almost has to be the reproduction of that expression. A nice thing is that it exists pretty much the moment that the work is created, and it extends for 50 to 75 years, depending on the jurisdiction, beyond the creator's death. And this is for the legal and economic rights associated with a copyright. So basically, after the creator dies, there's an extended period by which there can still be legal and economic rights. Moral rights are something different, though, but they are related to copyrighted material. I bring this up today because you might see them in things like employment contracts or contractor agreements, in particular in the software space. So if you've got engineers that are writing code, for example, you would want to make sure that in addition to owning, any intellectual property rights and the copyright in that material, that you also have a waiver for the moral rights as well. Because what moral rights do is that they give this extra layer of rights that includes the right to be attributed with the work. So for instance, if you're an author of a piece of art or a book, if you choose and you still have moral rights, you can ensure that you're always attributed with it, or you can say that I never want to be attributed to the work and I want it to be anonymous, and that's your right. But it also applies to the right to the integrity of the work. So if someone does not want the work to be changed or defaced in any way, as long as that author still has moral rights, they can block somebody from changing or modifying that work. Yeah, go ahead, Julia.
Are you going to do the story, the Eaton Center story now?
Oh, yeah. So I don't have a photo of it right now, but there is. If I'm sure folks have been to the Eaton Center and they've seen a beautiful flock of Canadian geese that's like flying above the escalators. There was actually a moral rights case related to that installation, in that the Eaton Center had put these big red bows around the geese's neck for Christmas, and of course the artist thought that was totally garish, and was diminishing the value of his work, and so sued them for the right to have them take those red bows off the geese, and he won because he still had moral rights for that work, and the Eaton Center had no right to modify or debase that work in any way. So it's a pretty interesting case. So there's a difference as well between registered IP and unregistered IP that's important to be aware of. So registered IP are those types of things that, you make a filing in a government office, you do go through some form of a prosecution or a registration process, and then you get some kind of a right associated with that for a particular term. And so that includes things like patents and trademarks and industrial designs. But there are also the unregistered rights, which would be things like trade secrets, confidential information, know-how, copyright, and unregistered trademarks, because you do establish trademark rights just by using your trademarks. But if they're not registered, you run the risk of somebody else being able to come in and block you, or to come in and compete with you for that mark. So that's just one of the distinctions between registered and unregistered trademarks. So of course, registered trademarks are a little more difficult and often more expensive to obtain, but they tend to be easier to enforce because you have a registered right, that puts the public on notice that this is your property. Unregistered marks tend to be easier to obtain and cheaper to acquire, but they can sometimes be harder to enforce. And so we will talk a little bit about trade secrets a little bit later on in that context. And it's important to know that one product can be covered by many different types of IP rights. And so I would encourage you to go back and think about, what it is that you're building in your companies and think about the different ways that it might be protected using intellectual property. So this uses one of Nokia's phones as an example. Here we can see there are trademarks. They've got their business name. Nokia is a trademark. Their product name is a trademark. And also the startup tone. So a sound can actually be registered as a trademark, which I find very interesting. Then, of course, you've got your patents and utility models. Utility models can be thought of as light patents. They're not actually examined. But they can offer quick protection, but you have to prove inventiveness and whatnot upon litigation. So here we've got data processing methods. So there's a popular belief that software methods are not patentable, a misbelief, I should say. They are, as long as they meet all of the standard requirements for patentability. So data processing methods are covered here: operating system, operation of the user interface, copyright, software, user manuals, ringtones. Again, in copyright, because that music can actually be written out in writing, and that can be copyrighted. And same for the tone and images. Trade secrets, of course. Some things companies do keep their secret sauce in-house. They don't want to disclose that to the public, especially if it's something that can't be patented. And then the overall design. And I see there's a question. So go ahead, Julia.
No, it's Payal's question, I think.
Hi, Payal.
Hi. Yeah, so my question was related more towards the data processing methods, because I think that applies to us. To give you an example, so we do GPS tracking, fleet tracking for small businesses. So small business can know where the vehicles are, assets are at any point of time, and it has its benefits. One of the differentiators for us is how efficiently we process billions of transactions and how quickly we do it in a cost-effective way. Many companies can do it, but then they would have Amazon cloud servers. They would go for more expensive options, and we've designed an architecture internally where we can do that for 1/10 of the cost, which we then transfer to a customer as affordable service. Now, if we were to pursue maybe like a data, would this first question is, would this fall under the data processing method patent, like something that we can explore if nobody else has done?
So we're going to talk more about patents, and I might want to put this discussion off about the requirements for patentability. So basically, the advantages that you're describing, those don't necessarily mean that you can get a patent. It would be a matter of looking at the steps in your process and whether when combined, they result in something that has a practical utility that's never been seen before. I will confide, I'm not a software patent expert. I'm a pharmaceutical and chemistry patent expert. But I do know that it's something that could be explored. And certainly if you talk to a software patent agent, my co-founder is actually one that I could refer you to.
Yeah, thanks. So you're setting us up beautifully for later on, Payal.
Yeah, okay, thanks.
So just so that everybody is aware, the number of IP filings that we're seeing globally continues to increase every year. So it's something that you should be thinking about. You shouldn't just dismiss, patents or trademarks or whatever, because you don't think that they're relevant. Just explore everything that you're doing inside your company and think about how you might be able to use IP in protecting your market share, because there is evidence that SMEs that have at least one registered IP right, for example, earn 55% more revenue per employee than SMEs with no registered rights. And if you own both a registered patent and a registered trademark, then basically they're looking at 75% more revenue and growing faster than SMEs with no registered rights. It's not to say that you can't have a strong IP strategy without these types of registered rights, but if it's a possibility to get them, it's definitely something that, they sit on your balance sheet, they add value to your company. It's something investors understand, and will often be asking about. So it's just something to consider.
Yeah.
And speaking of investors,
I just wanted to, we're going to switch right now and just get into some breakout rooms and see if we can engage a little bit from the standpoint of some typical investor questions. And this is this is kind of doing it before and after, but it's the goal here is just to see and listen to some of the different answers we hear from the other founders. To start with there. And I do want to point out, when we're talking about SMEs, small to medium enterprises, and IP, Canada right now, in both the provincial and federal areas, is really trying to improve the patent position of tech companies in general in Canada. So in doing that, because they realize they're behind the 8 ball. At the end, we'll talk about a lot of different things that are available for you for free, and that will help you move things forward quickly. And maybe it's an investigation that says, no, you don't need a patent, right? It's not always about patents, but we want to make sure you understand the different concepts there. Mm-hmm. So, Katie, if you could put us into 2 different rooms and make sure Jen is in one room and I'm in another room. We're just going to pose some questions that I would consider to be typical investor questions, and you are all from a bunch of different kind of companies, so your answers are going to be different as well too. So don't be fearful. It's more about practicing what you would say, and hearing what others would say.
Yeah, okay? And I think it'll be interesting too to see how you might answer the questions differently by the end of the session.